So House Republicans are finally getting their way. Hunter Biden agreeing to testify about his family's business dealings, but he wants to do it his way. He wants to do it in public. In a letter to the Republican Oversight Chair James Comer, Hunter Biden's lawyer wrote in part that a public proceeding would prevent selective leaks, manipulated transcripts, doctored exhibits, or one-sided press statements. Congressman Comer gave that a hard no, shooting back that Hunter Biden is trying to play by his own rules. Comer says they expect the first son to testify behind closed doors on December 13th, part of the subpoena that they sent him earlier this month. He says that Hunter can testify publicly after that. House Republicans have been investigating the Biden family now for months, alleging Joe Biden benefited from Hunter's business dealings when he was vice president, but those allegations have not yet been proven. We're joined now by trial attorney and legal analyst Mercedes Cowlin, and it's great to see you.
Great to see you, Colin.
And, you know, it's interesting to look at this in a lot of different ways. We'll start with the obvious, public versus private, behind closed doors. Why does it matter?
Well, certainly it doesn't matter when you look at the oversight rules that are very clear about how depositions are to be handled. Number one, you don't have an audience. It isn't public. This is an investigative body. And if you're really concerned about your testimony, guess what? In the rules, it says you get a copy of your transcript. You have the opportunity to correct your transcript. You have the opportunity to have your counsel present. With all those rules and the safety guards that are put in there, why then do you have to stand on principle and say, no, I want to testify publicly when you have all those concerns addressed readily right here in those oversight rules?
Let me ask you then, if you're representing either side, how they might look at it from a Republican's point of view, and why would they want this so badly to be behind closed doors? What is being out in public? What's the risk?
Well, Colin, that's really interesting because, frankly, you have to look at both sides, and you're right about that, because what is the concern? Obviously, all the questions are going to be asked are public. It's going to be in the transcript. Maybe they feel that there'll be a chilling effect, perhaps, but it's a little different than having in real-time questioning as opposed to having private depositions in the back where you can openly ask questions that may be those difficult ones. Switching gears a little bit, with respect to Hunter, I mean, he has obviously some concern. We've all seen how the media can be sort of manipulated. Things could be leaked. Things can be out there in the public. Not so much the media, but the participants in this entire investigative body. Who knows? There might be that type of issue that comes up.
He wants to be more public in general, it seems. Politico had an article about this, but it makes sense because he's gone out and hired new lawyers. And it looks like they were calling it like a counteroffensive. I don't know exactly what that means or how it plays out, but as opposed to running away from things, it seems Hunter Biden wants to take them on and wants it to be public.
That's such a great point, Colin, because it really does look like that he's switching gears. And say, there's no reason to continue. Obviously, you're not going to let go of this issue. Why don't I do it head on? Talk about it, ask me questions. I'm here. I have nothing to hide.
But could it affect I mean, he has a federal court case that he's dealing with, right? Is there any risk from his side of what this could do to the other case, testifying before Congress?
Oh, that's an excellent question. Certainly, as a defense attorney, I would be very concerned about my client testifying prior to the criminal proceeding. Because in criminal cases, you don't get to have a deposition. And frankly, you're not even forced to take the stand. You don't have to take the stand.
If it was behind closed doors, would they be able to use it in the criminal case?
No, only if there is some misstatement. So they can use it. It's obviously testimony that exists. If it conflicts with testimony that he gives at a later date, if he even takes a stand, you're not required to take the stand when it's a criminal proceeding. But let's say he does. He tries to explain it away before a jury, and then there's some inconsistency. Absolutely, that deposition was something that can be used.
That could be.
Thanks so much for watching. Go to joinnn.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.